Welcome to the League of Women Voters of Wisconsin's first of two webinars on the Wisconsin Supreme Court election on April 1st. This webinar is going to focus on ethics and money. I'm Joan Schwartz, an attorney, a member of the State League Board, and chair of the Impartial Justice Committee, which did excellent research and planning for this webinar. A big thank you to Kathy Annan, Jane Benson, John Callan, Myra Enlow, Cheryl Moranto, Janie Reeby, Dorothy Sky, and Eileen Newcomer. Please provide your comments and questions in the chat. There will be a question answer period at the end of the presentation. We all know that it's crucial that our Supreme Court be transparent and ensure equal and fair justice to all Wisconsinites. Yet, there are challenges that are affecting our Supreme Court that we must address. One of those challenges is the deluge of campaign contributions in our judicial elections. The astronomical amount of $56 million was the cost of our last judicial election in 2023, and this one is expected to be even more expensive. In 2010, the U.S. Supreme Court passed Citizens United, which has affected our elections for the last 15 years. It opened the floodgates to massive campaign donations, special interests, and dark money in all elections. A major consequence of this decision is the huge and often undisclosed amounts of campaign donations and dark money in state Supreme Court elections across the country. Tonight, we have Doug Keith from the Brennan Center of Justice at New York University's Law School, who will update us on the ramifications of Citizens United on our judicial elections here in Wisconsin. Also, we have George Penn from United to Amend, who will tell us about longstanding efforts in Wisconsin for our state to join 23 other states for a constitutional amendment on Citizens United. Because so much money has infiltrated our Supreme Court elections, and because the Citizens United decision will not be overturned anytime soon, we need to focus on the one single step the Wisconsin Supreme Court needs to take, and that is to establish a recusal rule, a rule by which a justice must disqualify him or herself from a case because of excessive campaign contributions to that justice or that person's attorney, when there is a conflict of interest for the justice or one's attorney, and where there is even the appearance of a conflict of interest. Without a recusal rule, there's little transparency and no system of accountability other than elections every 10 years to ensure that our judges are upholding the highest ethics on our Supreme Court. Confidence in our court system nationwide and in Wisconsin is at an all-time low. According to a recent Gallup poll, Americans' confidence in the nation's judicial system and courts has dropped to a record low of 35% in 2024, a decline from 59% in 2000. That's a drop of 24 percentage points in the last 4 years. This year marks the first time on record that judicial confidence in the court has been below 50%, pushing the national lowest in decades. Yet, surprisingly, over the years, Wisconsin Supreme Court justices still have what is called a self-recusal rule. That is, the justices are currently allowed to determine for themselves when they should be qualified from a case. We need to know where the judicial candidates, Judge Susan Crawford and Judge Brad Schimmel, stand on establishing a recusal rule at the Supreme Court should they be elected. Our speakers are well versed on a major issue of the lack of a recusal rule at the Supreme Court. Jay Hack of Common Cause will tell us about the Supreme Court's refusal since 2007 to establish a recusal standard for the court. And former Supreme Court Justice Janine Geske will discuss her time on the bench and her efforts to get the Wisconsin Supreme Court to establish a recusal rule. Okay, let's get started. Our first speaker tonight is Doug Keith. Doug Keith is senior counsel in the Brennan Center's Judiciary Program, where he works to promote fair, diverse, and impartial courts, and authors the Brennan Center's biannual reports documenting spending in state judicial elections. Doug is also a founding editor of State Court Report, a Brennan Center publication focused on state courts and state constitutional law. Take it away, Doug.
Great. Thank you so much. I'm going to share my screen quickly. Great. Is everyone still seeing just the slide on their screen?
Yes.
Great. Thank you all so much for having me as part of this very important conversation during what is obviously a very important year in Wisconsin. My name is Doug Keith, Senior Counsel at the Brennan Center for Justice. We are, for those that don't know, a nonpartisan law and policy institute that seeks to improve systems of democracy and justice. And for more than 20 years, the Brennan Center has documented the political pressures facing state judges and justices and advocated for reforms to strengthen courts and enable them to live up to their responsibilities in our democracy. If there are three takeaways I'd like you to have from my section of the presentation today, this is them. One, Citizens United led to a campaign finance environment in which large dark money groups can thrive. Two, these groups have taken on an outsized role in state judicial elections, in some ways more significant than in other elections that folks may think about more often. And three, since 2022 in particular, we are really in a new era of state judicial politics that makes a lot of what has happened in previous years look almost quaint, and which makes this conversation only more urgent. I want to start by talking about Citizens United. What happened in this case? The case was a conservative nonprofit group called Citizens United, challenged campaign finance rules after they were prohibited from promoting and airing a film that criticized presidential candidate Hillary Clinton too close to the presidential primaries. A 5-4 majority of the United States Supreme Court sided with Citizens United and ultimately ruled that corporations and other outside groups can spend unlimited amounts of money on elections as long as that spending is independent of the candidates. Why did the court say this? Well, in the majority opinion authored by Justice Kennedy, the court wrote that limiting independent political spending was ordinarily justified by risks of corruption, but when corporations and other groups are spending independently of the candidate, those risks are not present. There is no risk of corruption, and thus these prohibitions violate the First Amendment right to free speech of these groups. Both of these opinions assumed that both independent spending wouldn't be corrupt and that the spending would be transparent. In fact, the court sort of endorsed disclosure and transparency in its opinion, but both of these assumptions really have been proven incorrect. With this decision, the Supreme Court overturned election spending restrictions and law that dated back more than 100 years. Previously, the court had upheld certain spending restrictions, arguing that the government had a role in preventing corruption. But in Citizens United, the bare majority of the justices held that independent political spending just didn't present a substantial threat of corruption or the appearance thereof. As a result, the world we're in today is one in which corporations can spend unlimited funds on campaign advertising if they are not formally coordinating with a candidate or political party. Importantly, that's where Citizens United ended. The decision was about whether corporations can spend unlimited funds. But there was a 2002 case decided by a lower court called Speech Now, which is nowhere near as famous, but maybe is just as important. And in that case, a lower court followed the logic of Citizens United and ruled that those outside groups that could spend unlimited amounts of money, they could also raise unlimited amounts of money. They could take in unlimited contributions for the same reason, that there was no risk of corruption because these groups were spending independently of the candidate. This led to the creation of super PACs, which are PACs not bound by spending limits or contribution limits because they are not giving to candidates. Super PACs are often required to disclose their donors, but as many folks may know, if you try and dig into those disclosures, you may find the names of other opaque, benignly named groups, and it may give you no information about who is actually trying to influence the election. Moreover, while super PACs are technically prohibited from coordinating with candidates, weak coordination rules at the federal level and in the states have really made these prohibitions somewhat ineffective. It's maybe worth noting that this year is the 15th anniversary of Citizens United, and one of my colleagues recently wrote, looking back on the decision, that the last few weeks in particular have made clear that a very small group of Americans now wield more power than at any time since Watergate. And this is perhaps the most troubling result in Citizens United. In a time of historic wealth inequality, the decision has helped reinforce the growing sense that our democracy primarily serves the interests of the wealthy few. So I'm here to talk about modern judicial elections and not just Citizens United. So I want to move on. 38 states, as folks may know, use elections to select at least some of their high court judges. States adopted elections in the 19th and 20th centuries as an anti-corruption reform, which may make you laugh when you think about judicial elections today, but that's really the root of this tool that so many states use today. These elections used to be fairly quiet affairs, but that has changed, as you all know. The chart you're looking at now shows that in 1999, 7 states had a sitting judge who'd been in $1 million race. By 2016, 20 states had that, and this is all adjusted for inflation. To give you another data point, before 2020, we'd never seen more than one state with $10 million in spending in their state Supreme Court elections in a given cycle. But in 2020, 5 states saw this, and now we regularly see multiple states spend it with more than $10 million of election spending on their judicial elections every cycle. And it isn't just about, the concern isn't just that the races are getting more expensive. Where this money is coming from is really changing, and this is really where Citizens United's impact can be seen. What this chart you're looking at now is trying to show is really the difference in these races before Citizens United on the left and after Citizens United. And since Citizens United, outside special interest groups have taken on a substantially larger role in state Supreme Court elections. They regularly account for more than 1/3 of all spending across the country and as much as 3/4 of the spending in states that these groups set their sights on. And as I mentioned, today we are in an entirely new era when it comes to state Supreme Court elections, with really supercharged spending in these races. That's in large part because the US Supreme Court's decisions making clear that it will not protect particular rights like abortion rights or democratic institutions in the fights over partisan gerrymandering. These decisions have resulted in some of the highest profile legal fights about abortion rights, about redistricting, playing out in state courts, and really shining a light on how important these courts are. This has meant greater attention on these courts from wealthy political interests. Just to give you some top lines from the 2022 cycle, which I know feels ancient at this point, but we're still tallying the numbers from the 2024 cycle. In 2022, in total, candidates, interest groups, and political parties spent a little over $100 million on state Supreme Court elections. That was nearly twice what we had ever seen in any prior midterm cycle after adjusting for inflation. And midterm cycles tended to be quieter than presidential cycles by a large amount. And yet that was almost the most expensive cycle ever, midterm or presidential. Outside groups that year, the ones who are thriving because of the environment created by Citizens United, spent more than ever before. They accounted for $46 million in spending, 45% of all the money spent in the race, a larger share of the spending than they have ever spent before. And for the first time, interest groups on the left and the right spent almost the same amount on Supreme Court elections. In the past, there has the conservative spenders have focused much more on these races than groups on the left have. But that's one thing that seems to be changing, is we're really seeing a lot of money from the left and from the right. And if you look nationally, there's really parity at this point, although the story does differ depending on the state you're looking at. And then you'll see this last bar I've added to this graph just for this group. The 2023 Wisconsin Supreme Court election, it can't be overstated how significant this race was when you're looking at trends in spending in state Supreme Court elections. This was the most expensive state Supreme Court election by far. And again, I want to be clear about just how much of an escalation it was. The 2023 Wisconsin Supreme Court election saw more spending than every state Supreme Court election in the country that took place in the 2017-2018 cycle. That was about 60 or so races across the country in those 2 years, 2017 and 2018, including a Wisconsin Supreme Court election that saw a decent amount of money. And yet the 2023 Wisconsin Supreme Court election saw more money than every race that cycle combined. And there's really no sign of the spending in these races slowing down. In fact, the other race that took place that year in 2023 was a Pennsylvania Supreme Court election, which it didn't break the record that Wisconsin set a few months earlier, but in fact, it became the second most expensive judicial election ever. And so it really is illustrating that we are in a completely different era when it comes to these races in the wake of Dobbs, making this conversation only more urgent. And so why does this money matter? Why do we care about the changes in spending in state Supreme Court elections? There are a few reasons, as you might imagine. One, most of the spending by the outside groups is non-transparent. The actual source of the spending cannot be identified or be very difficult to identify for any member of the public or the press. We actually did an analysis at the Brennan Center a long time ago of spending in elections generally, and outside groups in elections generally, not just judicial elections, to see how much of the outside spending was what we would call dark money or opaque in some way. And then later we did that analysis just for judicial elections, and we found that the outside groups were actually more opaque, harder to identify the true sources of the spending in judicial elections. And that's because of how sophisticated the group spending in judicial elections are. Ultimately, this leaves voters in the dark and creates potentially enormous and unseen conflicts of interest. My second reason this matters is there's at least some evidence that judicial candidates are actually coordinating with groups behind the scenes, enabling candidates to benefit from those groups' support while circumventing all of the contribution and ethics rules that are supposed to limit those groups' behavior or the judge's behavior while deciding cases on the bench. This spending also matters because these outside groups disproportionately run attack ads, distorting judicial records, and they're disproportionately likely to attack candidates of color, worsening existing racial disparities on the bench in states across the country. Spending like this also makes it harder for the public to be confident that judges are deciding cases independent of political pressure. We are in a moment where it is just so important that the public actually have confidence that their courts are doing something different than the raw politics that the other branches are doing. And the way judicial elections are operating today, it's just a lot harder for them to do that. Lastly, there is a growing body of research, as this slide says, that this money actually changes how judges decide cases, that the political pressures judges face when they're up for election influence judicial decision-making. There's evidence that judges are more likely to rule in favor of major donors in election years. They're more likely to rule in favor of political parties that support them, and they're more likely to rule against defendants in criminal cases, not because the parties in those cases are giving them money, but because they're afraid of these attack ads and afraid of being tagged as soft on crime. And we're already seeing some of those ads in the Wisconsin Supreme Court election this year. We did a survey a while back of voters, and 90% of the respondents said that they thought money in judicial elections influences judges' decisions. And all of this research suggests that those voters were not far off from the truth. So one important takeaway from my presentation is just that the existing ethics and recusal rules are not cut out for this new era of judicial politics. I don't want to spend too much time on this because I know others will speak to it, but most states have adopted the ABA's model code of judicial conduct that you see here, which is supposed to limit the way that judicial candidates interact with political parties. But these rules don't address how candidates can interact with outside groups that now really dominate these elections. Following a really important U.S. Supreme Court decision called Caperton, in which the court recognized that outside spending in judicial elections can require recusal in order to protect parties' constitutional rights to due process in court. The ABA ultimately withdrew proposals to update the model code and the rules because they didn't have the support of judges across the country. Similarly, recusal rules, which exist in codes of conduct and in statutes in some states, just have not been updated to meet the reality of judicial elections today. So I want to wrap up my section by just reiterating that Citizens United played a role in dramatically changing how judicial elections operate in states across the country. And as you can tell from the recent cycles of judicial elections and what you've seen firsthand in Wisconsin, the problem seems to only be getting worse, not better, with these courts increasingly at the center of fights over democracy itself. This conversation is coming at a really crucial time for shoring up courts' ability to be independent and shoring up the public's trust that these courts actually are independent. I'm happy to talk more and answer questions in the Q&A, but I just want to say thank you all for having this conversation and for having me be a part of it.
Thank you, Attorney Keith. That was very helpful to have that background. Our second speaker is George Penn of United to Amend, who will discuss the many long years effort in Wisconsin to establish Wisconsin as the 23rd state to support a constitutional amendment to overturn Citizens United. George spent most of his career as an energy efficient and renewable energy consultant until 2012, when he shut down his business to build the movement needed to restore a republic from our money-owned political system. George?
Thank you, Joan. And thank you for inviting me with this group of good professionals here that I consider partners. And I'm, pretty much the outreach person for United to Amend. And our goal is to build a movement to get big money out of politics through a constitutional amendment. Some call it the 28th Amendment, but everybody calls the next amendment that, of course. And that's what we're doing. We're building the movement to do that because we believe it's going to take a movement, just like suffrage and civil rights, because where we are today. And so that's important to us in acting in that way. And we believe we have to work on all these reforms, would be fair maps, voting, final five voting, and of course the judicials, getting that to be trustable again. All have to be worked on. But we think if you don't get money out of politics, the rest of them are not durable. This is a keystone reform. If we don't do this, the rest of them cannot be trusted to be kept. And so that's what we're working for. And we work with a national partner that's working on, they do more the lobbying side. We do the working with citizens to get the citizens to demand reforms. And that takes movement length of time. We're talking decades here. So we're just starting a movement that will go on beyond me for sure. So, okay, so I just want to give you some detail of how do we do this? How do we build this movement? And what kind of tasks are we doing here? Most importantly, or most fluid for us, is that we get local resolutions passed calling for the constitutional amendment. 22 states have made the call. Wisconsin's not one of them. So that's our first benchmark, is to get our state to make the call for the constitutional amendment. And right now we have 178 communities, and I have a map and a list if you'd want it, that have passed our resolution calling on our state legislators to call for the constitutional amendment. And we continue to work on that. I got 5 in the works right now. And that's most of our effort. And then we also work with, I'm working with the Lutherans, the ELCA, and the and other faith communities. And we have a national interfaith caucus working on this. And I work with in other states with people. We've got about 92 faith communities that have passed a resolution calling for this constitutional amendment. And then other than that, I guess our goal is to educate the public, bring them along to the point where they demand, and that's going to take a long time, this thing to get the amendment to the Constitution and to build power at the citizen level, while most of you who will be talking today work on what's called a reformer. That's inside the system. We work outside of the political system with the citizens, and we're called change makers. So the reformers and the change makers need to work together, as I'm sure we will be in the future. Thank you, Joan.
Thank you, George. I have a question. Would you explain a little advisory until you no longer could because they're illegal?
Yeah, so we about 178, about 110 of those are referendum before the resolution. So 110 of them we had the citizens vote on it, and that's referendum. Well, in the bill where they tell where the money's going in 2023, I forget the name of it. It's not the budget bill; it's the bill after that. And in that, they put one sentence in there that said it's illegal for communities to have referendum now. So we can't get any more referendum, but we're going to keep getting the resolutions. The referendums help us build power, and they've slowed down our ability to build power, but they haven't stopped us.
And how are you doing it now with the resolutions?
We just go to, we don't ask them to put it on the ballot. We go in and say, Council, will you please pass this resolution? That's why I got 5 of them going right now. We have people going into their councils or their town boards or whatever with our resolution. We have a handbook for them to do, they can do everything. And then we go in there and we ask the council or the board to pass it, and they pass it. Almost all of them.
Okay, I'm sure we'll have more questions as we move on. Thank you. Our third speaker is Jay Hack. Jay Hack became the executive director of Common Cause in Wisconsin in 1996. Common Cause is Wisconsin's largest nonpartisan citizens reform advocacy organization with more than 8,800 members and activists. It's considered by Wisconsin's major newspaper editorial boards and by pro-reform legislators of both major political parties to be one of Wisconsin's most effective and influential state reform organizations. Jay is currently the longest-serving Common Cause state director in the country. Okay, wow. Jay.
Joan, thank you. And boy, what a terrific turnout for such a cold and somewhat depressing January evening. January, as I've often said, is the longest 4 months of the year. But we're near the end. I suspect that Joan asked me to talk tonight to give kind of a chronology to how money has infected Supreme Court elections in Wisconsin over the years. I think in part because I've been with Common Cause for nearly 30 years, and also because I was a history major in college. So it's my pleasure to do that. Let me begin by saying that in 1996, when I started at Common Cause, the Wisconsin Supreme Court, and indeed the Wisconsin judicial system, was considered the model for the nation. Wisconsin elections were relatively low spending affairs. It was important to be impartial. It was important to receive high ratings from the Bar Association. Judicial temperament was considered to be very important. And people then, as now, wanted their judges not to be partisan. They wanted them to be impartial, to interpret the law. And so for the 1990s and into the 2000s, again, Wisconsin was a model for the nation. In 2000, the Chief Justice at that time, Shirley Abrahamson, invited me to a judicial conference in Chicago as part of her delegation. And at that conference, there was the beginning of big spending beginning to occur in some states in judicial elections. And this was terribly alarming because, as Doug had mentioned, this was something that you didn't see in the nation very much before. And Wisconsin at that time was, again, the model for the nation. We had still in place although underfunded, a partial public financing system in place. And by and large, when candidates ran for the state Supreme Court, they abided by the spending limits, which back at that time were about $400,000 a year. Quaint, isn't it? $400,000 a year. And there was some partial public financing, which meant that candidates could receive money from the public instead of from special interest groups. It was only about 100,000 at that time. But still, candidates, even though these grants weren't fully funded, they basically adhered to the spending limits. And that was pretty much the case through most of the 2000s. There were some exceptions, some races where the elections were higher. But it really wasn't until 2006 when one of the chambers of the legislature, the Assembly, the Democrats, took control of it. And outside special interest groups, and I will name them for you, Wisconsin Manufacturers and Commerce, Wisconsin Club for Growth, made a calculated decision that their money could be better spent, not just trying to influence elections in the legislature, but to begin to pour them into judicial elections, specifically the Wisconsin Supreme Court. And so 2007 saw the first really mega dollar Supreme Court election in Wisconsin. That was the election in which Annette Ziegler was elected to the Supreme Court. She now, of course, is the Chief Justice of the court. And in that particular race, $7 million was spent, which was an abhorrent amount. People were shocked all over the state of Wisconsin, and indeed, I think, all over the country. And that trend continued in 2008 when Justice Louis Butler ran for re-election. And in one of the most vicious, racist campaigns to be conducted on Wisconsin airwaves since that time, and certainly at that time, Michael Gableman narrowly defeated Justice Butler, and $8 million were spent. Most of the money, again, from these outside big special interest groups. Now, that created a real problem and a real uproar amongst the citizens of Wisconsin and in the legislature. And in 2009, both houses of the Wisconsin legislature, with bipartisan majorities, passed what was called the Impartial Justice Law, which took all of the private money out of Supreme Court elections. It was justices or candidates for the Supreme Court were provided with $400,000 to spend, provided they limited their spending. I'm sorry, if they limited their spending to $400,000, they were provided with public grants of, I think, about $1 million, as I recall, to run their campaigns. There was outside money that was allowed as a result of a Supreme Court decision. But in 2011, the first and only Supreme Court election in which we had this impartial justice law in place, both Justice David Prosser and his opponent, Joanne Kloppenberg, spent no private money, and they spent a total of whatever $1 million each for the Supreme Court election, and that was the result of the election. It worked pretty well. Unfortunately, in 2011, a lot of things happened in Wisconsin. There was, of course, Act 10. Scott Walker was elected governor. Republicans, under then competitive maps, seized control of both chambers of the legislature. And one of their first actions was to repeal all public financing of elections in Wisconsin, including the impartial justice law. So it was gone after being in place for not even 18 months and only one Supreme Court election. And so, as Douglas has indicated, we were off to the races. And shortly before that, in 2010, as Doug mentioned, the Citizens United decision had been handed down by the U.S. Supreme Court, narrow decision. That opened up the floodgates for outside money. But interestingly enough, right after that, the League of Women Voters of Wisconsin petitioned the Wisconsin Supreme Court because of their concern about Citizens United and the money that they saw flooding into Supreme Court elections. And the petition was to ask for a recusal rule. That is, for justices not to participate in a case if they were the party in a case, if they had contributed as little as $1,000 to a justice on the Supreme Court, or an outside group had spent $1,000. And it was a serious proposal. It met a lot of, it received great editorial support, including from all the good government groups. but the conservative control of the Wisconsin Supreme Court at that time rejected it on a 5-2 vote, and it was worse than that. They then decided to adopt a recusal rule that is in place now that was written by Wisconsin Manufacturers and Commerce and Wisconsin Club for Growth, which basically allowed each justice to decide for themselves to recuse or not, self-recusal. And so that has been in place since that time, 2011. Wisconsin is considered to have the 47th least strong or weakest recusal rules of any state in the country. I always like to point out that Cook County, Illinois, Chicago, has stronger recusal rules in place for judges who are the recipients of campaign contributions or of outside spending than Wisconsin currently does. So those are the recusal rules that are in place as of now. The trend continued, and in 2015, and again, this was something that Doug referenced, the Wisconsin legislature and Scott Walker decided to repeal basically any limits on campaign finances in Wisconsin, including something called coordination, which strictly prohibited outside groups from coordinating campaign activities with candidates, including Wisconsin Supreme Court elections. And those were repealed by the legislature and by Governor Walker, which allowed for this unlimited money that we now have in Wisconsin that infects our Supreme Court elections to the tune of $57 million in 2023, and widely expected to be at least that this coming year for this current election. The recusal, though, the recusal drive and the recusal movement took off very strongly after the 2015 elections. And Justice Geske, who will go into this a bit more, and Justice Butler and 57 other retired justices petitioned the Wisconsin Supreme Court to put into place strong recusal rules, various levels, 10,000 for Supreme Court justices, 1,000 for circuit court judges, I think 3,000 for Court of Appeals judges, 500 for municipal court judges. If you had been the recipient of a campaign contribution, you had to automatically sit out of the case. And the Wisconsin Supreme Court, the conservative majority, rejected the rule, and they went further. They decided to close all open conferences in the Wisconsin Supreme Court after that time. So they not only said, no, we're not going to have any recusal, but we're not going to let the public know what we're talking about when we make these kinds of decisions. And of course, that was absurd and abhorrent. So the question now becomes, and thank goodness we have Janine Geske here to talk about this and her experience on the court. The question becomes, with this huge amount of money that will now be spent in this election, and by the way, keep in mind we have Supreme Court elections occurring for the next 4 years. The question will be whether or not the Supreme Court has an appetite to adopt stronger recusal rules with all this influx of money. And in Wisconsin, it is the Supreme Court that decides whether or not to recuse. So that's going to be an interesting development that we will have to see what happens after this coming election in April 1st of 2025. I was going to say 2016. The years are all blurring together for me. So I think I've taken enough time. As my board always says, less Jay Heck and more Janine Geske is always a good thing. So I'll turn it over to you, Joan, and for you to introduce Janine.
Hey, thank you very much, Jay. There'll be questions at the end, I'm sure. Okay, our last presenter is former Supreme Court Justice Janine Geske. She was on the Wisconsin Supreme Court from 1993 to 1996. From 1998 to 2013, she was the Distinguished Professor of Law at Marquette University Law School, where she founded and directed the school's Restorative Justice Initiative. From 2022 to 2023, Janine returned to the law school full-time to set up and manage the newly endowed MULS Andrews Center for Restorative Justice. Take the floor, please, Janine. Thank you.
Thank you, Joan. Well, I thought what I would do is put you along with me in the pilot seat a little bit to be able to look at, from a judge's standpoint, what has happened and at least some of the issues that I see, and there are lots of issues. I smiled at Doug's comment about the quaint years because I was, I didn't think they were quaint, but they were quaint. I was appointed, and Joan didn't mention this, I was a circuit court judge in Milwaukee for 12 years before I was on the Supreme Court. So I have run 3 different elections, 2 contested, 1 uncontested. I like the uncontested better. When I just want to go back to 1981, when Governor Dreyfus appointed me to the court. At that time, I think we spent maybe like 30, 40,000 on a countywide race. And whether it was at the circuit court or at the Supreme Court, as a judicial candidate, what we really tried for was bipartisan support for our candidacy. I just want to take you back for a moment to the founders in Wisconsin. When the Constitution was created, there was a vigorous debate whether we ought to be appointing justice or whether we ought to be electing them. And ultimately, our founding fathers decided to allow and to make constitutional elected judiciary. They also decided that they would be nonpartisan races, which was a good thing and certainly is a good thing. The third thing that they did, which is different from other states, and thank God they did this, that only one justice can be up at a time. Now, you can look at the state of Pennsylvania, where there's going to be a lot of money spent on a different kind of a judicial race. And I think there are 3 justices up at one time. And so it was to help create stability in the court. But back to being a judge in 1981, we would try to get public defenders and prosecutors. We would try to get insurance defense lawyers and plaintiffs lawyers. We would try to get family lawyers. We would get community leaders. We would get formerly Republican governors and former Democratic governors. So we tried to show by our support that we were bipartisan, that we were respected, and so the races were very small. We spent a little money. We had to get the word out, and a lot of the running, even when I ran as a Supreme Court justice, was really getting out to the public. I mean, I don't know how many legal women voters groups I saw around the state when I was campaigning in 1993 and 1994. But every Rotary group, every Lions group, and I was a strong proponent for the elected judiciary. One of the reasons was it made judicial candidates, go out and talk to the public. That we had to sit and listen to what people's concerns were about the system, not about cases, but about the system. And we had the opportunity to hopefully explain and educate people on what the court did and didn't do, ultimately what the Supreme Court did. And there is a lot of misunderstanding about the role of the Supreme Court. And so that really gave us an opportunity. So I was a big proponent of the elected judiciary. In 1993, when I was appointed by Governor Thompson and then ran in 94, we had public financing. Jay mentioned that. And I think, if I remember right, we could raise, I think, like 200,000 or 225,000. And then we got another little bit, I think it was like 25,000 from public financing. But the public really respected candidates who restrained themselves from not raising that kind of money. And that, that was a big question we always got asked when we were campaigning. Are you taking public financing? Will you be bound by the rules? And most of us did that at that time. And, it was good. So what's happened, when you listen to some of the history you've heard, and I'm just going to drop in a couple other cases, you can see the importance of the judicial branch of our government, whether it's at the national level or the state level. You've heard mention of Caperton. You've heard mention of Citizens United. These cases have impacted our judicial elections in a devastating way. And we finally risen to the part where we just had a $50 million campaign, which is just unbelievable to me. Our ethics rule, when I'm going to concentrate on a justice, was really that you didn't sit on a case that you felt couldn't be fair. So, if my husband was arguing the case, I couldn't sit on the case. Or if, my daughter was on the case, or whether my former employer was on the case. We had all reasons why not to sit on cases. I can remember when I was running in 1994, I got a contribution, I think of maybe $2,500 from a lawyer who had a case pending before the court, and I sent it back to him. I didn't even want to receive any money from anybody who had anything before the court. But we really struggled with a lot of those issues. And I think it's important for you to understand that when the justices are deciding whether to recuse or not, there is a huge tension. And the tension is we have 7 justices on our Supreme Court. All appellate courts have an uneven number so that you wouldn't have a tie vote if everybody participated. And what happens if somebody recuses themselves on a case, there are only 6 justices. Many states have provisions allowing for some other judge to step in. Our Constitution does not allow that. The 7 justices are the only people that can sit on the case, and if they recuse themselves, they're not there. So we have had in the last few years a couple of 3-3 decisions. I'm going to bring that back in a few minutes to talk about why that creates some issues for recusal rules. So our court, got to a place philosophically, they did not want to regulate campaign finance and the contributions. And you've heard both, the efforts by the League of Women Voters, and then ultimately a number of us judges, trial and appellate judges, asking the court to do something about setting limits. And our thought was, we're not going to be able to prohibit, unless there's a constitutional amendment, prohibit people from contributing to campaigns. But if we can prohibit justices ethically from sitting on the case, then people won't give the money to them because they want their favorite judge to sit on their case. And if they gave the money and the judge recused themselves, you wouldn't have the benefit of that justice. So that was really the thought. These were ethics rules that we were trying to promote because we really couldn't change, the United States Supreme Court decision. And unfortunately, our court rejected, as you heard, both the League of Women Voters proposal and the petition we gave without discussion. Now, I am highly critical of the majority of the court for doing that. And this is the reason. Historically, when we would get a real proposal, we didn't quite know what to do. We would appoint a blue ribbon panel of experts, maybe from around the country, to take a look at what other states were doing, what people were doing, and make some recommendations to the court of what made sense. I don't know if $10,000 contribution is the right number. I don't know what the number is, but the court refused to even study the issue or even discuss it in open conference. So they just completely shut out any change in the rules. One of the reasons our rule is 47th in the country is not only does it say the judge decides, it says a campaign contribution alone is not enough to kick somebody off a case, which means, there's no limit to whatsoever. Now, you heard about Caperton. Caperton was a case that involved a Supreme Court justice who had taken a $3 million contribution during his campaign from an insurance company that had a huge judgment against it. He sat on the case after he was elected, and it involved a $50 million verdict, and the case was affirmed on a split decision. And the United States Supreme Court said, this goes to the due process of the parties. There's so much money to a judge who is making the decision. Our court has not given any weight to that yet. Maybe it will at some point. But we're not in a position that there's any body to review whether somebody recuses themselves or not. The most important part of our independent branch of government is that we are nonpartisan, that we are impartial, that we are independent, that we are not connected to parties, that we're not connected to interests. And we have lost that. And as you see, our races have sort of degenerated into big legislative races. I was just quoted in the New York Times this week on this issue, and it's like we're electing another legislature, but only 7 of them, one at a time. And I'll tell you that one of the things we're going to talk about, and I don't know if I'm going over time here, I'll be careful, one of the things we're going to talk about is the importance of at least the public pushing. If we can't change how we do all this, at least to propose the court and put pressure on candidates who are running for the court to put into effect some ethical bounds on contributions. Now, I'm going to tell you what the problem with that is. The problem is the last race, our candidates, you know, they spent almost equally, spent over 50, close to 50 or over $50 million. They are predicting, national people, that this race is going to go higher. The question is, if one of the judges who gets elected is going to sit on the court, how are they going to say that you can't sit on cases if you've been given, you know, say $100,000 from the Democratic or Republican Party, or you can't sit on a case where 100,000 has been given, or take whatever number you want. The problem is that these candidates and people on the court now have taken those contributions legally, but we're in a position of, you know, I'm sure that candidates are going to say they're in favor of it, but the question is, what are they in favor of it and how are they going to react? I'm such a believer in the importance of our judicial branch, and I think never before is that branch more important than it is now, with all the discord and the problems and the legal issues coming up. And as a result, I think, you know, it is absolutely critical, as much as we can, is to try to help shape our court and return it as much as we can to those court peers, at least where our judges and candidates are being impartial, not representing where they're going to vote, not representing a party, but saying, look, I'll give you a fair shake if you come into the courtroom.
Thank you very much, Janine. Okay, we will come back to questions for our four speakers, but right now, Brandy Rodriguez, a staff member of the League of Women Voters of Wisconsin, will explain what the League has prepared for all of us to engage in preparation for the Wisconsin Supreme Court. Brandy?
Yes, good evening. I am filling in for Deborah Cronmiller, so I'll do my best. But if there are any lingering questions about resources or additional things that you want to find, please feel free to reach out anytime to get access to those. So I'm going to share my screen. All right. So I've gone to our website. It's lwvwi.org. This is our homepage here. And I'm going to go over here to where it says toolkits resources. And we have this wonderful page with lots of links on here, but the one that we're primarily looking at is right here, Spring Judicial Elections Toolkit. And as you can see, there is tons of amazing and wonderful resources linked within here, templates, graphics, and things like that, that our Molly Carmichael, who was our communications manager, put together before she left us for another wonderful opportunity. And so if you do need assistance, just know that Molly is unfortunately no longer with us, but you can email lwvwisconsin@lwvwi.org. And Delaney, if you wouldn't mind just dropping that in the chat, I'd appreciate it. So please avail yourself of this wonderful toolkit. It's very comprehensive. It has English and Spanish, fact sheets and brochures, and other items like social media, graphics, and things like that to help get out the vote. And then I'm going to go back to, so I'm still on the toolkits and resources page here. If I scroll all the way down, we can also take a look at the Fair Courts series link here, and that will bring us to this wonderful page and the Fair Courts webinar series. And all of those webinars are linked in this page. So if you care to go through those and learn more about Fair Courts, you can do it all on this one page. Another optional resource is impartialjustice.org. That is a website that the League also manages. It's just separate, it's its own entity. So that's again, impartialjustice.org. And I'm going there now, and it looks like this. And as you can see, that's It's by the League of Women Voters of Wisconsin, but it's all about fair courts. So we have under elections here, an educational resource tab. So if you click on that, this is another treasure trove of resources for you to utilize at your discretion. Again, here's that spring judicial elections toolkit for 2025. And here's another link to that Fair Courts video series. And then some additional links to our partner organizations like Common Cause, Wisconsin Democracy Campaign, and the Brennan Center for Justice. So we have some representation from some of those partners here, which is wonderful. And one more thing that I wanted to share with you guys at the request of our lovely Eileen Newcomer, voter education manager at the State League, is vote411.org. So vote411.org. Many of you are leaguers and you're familiar with this platform. But if you go to vote411.org, you can register to vote, you can check your registration, and you can also get information about candidates and what's on the ballot. So that is what I have for you. Again, if there's something I glossed over too quickly or that you just want some more information about, please reach out to us and I am happy to share that with you.
Thank you, Brandy. We're going to open up for questions and answers with Myra Enlow, and I'm going to ask a few questions first. Doug, can you explain the difference between super PACs and what had been traditional PACs?
Yes. So the key difference is that super PACs are political action committees, groups that spend in elections of some kind. What super PACs committed to doing was doing all of their spending independent of candidates. So they are not coordinating with candidates and they're not making contributions to candidates. Because of them doing all of this work independently, or at least independently in name, since we know that a lot of times independent spending is not actually independent. But because they say they're doing their work independently, they get to exploit all of these loopholes that have been opened up by Citizens United and its progeny. So they get to spend in unlimited amounts to support a candidate. They get to take in unlimited amounts of money. They can take a super PAC can take a $50 million contribution from a tech mogul. A regular PAC cannot do that under most campaign finance law. So the big difference is that super PACs say they're doing their work independently of candidates, and as a result, they get to take advantage of the lack of any regulation around them.
Okay, thank you. And can you explain how they've actually gotten into the super PACs that are giving the money are actually getting into the campaign itself? What are they doing?
So I mean, it really differs by campaign. In some instances, there is probably outright coordination that the public's not aware of. We don't know all communications that happen between campaign staff and super PACs. In some instances, we know ways that campaigns and super PACs are coordinating. So one thing campaigns will do sometime, and this has been lampooned a bit by some TV commentators, but campaigns will publish B-roll, that is footage of the candidate without any sound. They'll post it on YouTube or something like that, with the understanding that they can't coordinate explicitly with a super PAC, but they know super PACs will find the footage and then just use it for their campaign ads. They'll do sort of similar to B-roll. They'll publish polling data or messaging information that they want super PACs to take advantage of. And in another way we've seen this play out in judicial elections, both in Wisconsin and in some other states as well, is you see candidates who know they're going to be in competitive races because of the way judicial elections have taken place and really changed over the recent years. In a competitive state, they can be pretty sure that this outside money is going to come in and support them. And so we will see some candidates just do nothing. They don't raise any money. They don't spend any significant amount of money because they know they don't have to. And they know these groups are going to come in and effectively run a campaign for them. And so there's lots of different ways that we've seen coordination or the appearance of coordination play out. But it's definitely something that's happening right now, given all of the lax campaign finance laws at the state and federal level.
Is there any control over any government entity that's over control of these campaign finance?
Well, every state has campaign finance laws, has a body that's that's tasked with enforcing those laws. And the federal government, of course, there's federal campaign finance laws and the FEC that is tasked with enforcing them. But often these bodies are broken, sometimes by design. The FEC is structured in a way that it will always disagree along partisan lines and never be able to enforce any meaningful rules. The laws themselves are weak. As Jay spoke about, the laws in Wisconsin have been strong in the past, but they have been deliberately weakened in order to undermine regulation of campaign finance. So it is absolutely possible to rein in some of these practices, but there are just many interests who are opposed to that. And so it is important that this continue to be an issue that legislators and judges and others are aware of as they do their work, because just because these changes have been made in the past does not mean that there's a way to build a stronger campaign finance system.
Okay, thank you. And Janine, I have one question for you before I have Myra start with the chat questions. This blue ribbon panel that you discussed, how would these experts be selected across the nation, and who would do this selecting?
Well, in the past, when that happened, it was the court that did that. They'd come up with names, or there'd be, people would call people and say, whether it's the Brennan Center or other institutions or universities or bar associations, and you'd look for people who've done a lot of writing, done a lot of research, but the court normally appointed that group. And, you have different justices with different interests, and they generally would agree to have, this panel and somebody be reported. So that's how it usually is done, and certainly could be done on this issue.
Okay, thank you. Okay, Myra Enlow, if you can take over questions from the chat, I would really appreciate it. Thank you.
Okay. So Penny is asking if we know of other states that allow coordination with super PACs at the state level. As Jay noted and Penny noted before Jay, that in 2015, our law changed to allow coordination of candidates and campaigns. So she's curious about what's happening in other states.
Yeah, I could answer that. Wisconsin, when we changed our campaign finance laws, or Governor Walker and the Republican legislature did in 2015, they went to the furthest extreme possible to open up the system with regard to unlimited money being put into our system. And there are states, for instance, that still prohibit campaign coordination between outside groups and candidates. For what are called issue ads. Those are prohibited in Doug could correct me if I'm wrong, but I believe that they are illegal in every other state in the country except for Florida and Wisconsin, and it's still illegal to have that kind of campaign coordination at the federal level for congressional elections. So we chose the wildest of the Wild West scenarios that you could imagine for campaign coordination. And then the other thing I should note in 2015 was there used to be limits in Wisconsin on how much political parties and entities could participate or contribute in a campaign. It was roughly $150,000 for each political committee was the limit. Now it's unlimited. That's why you have, for instance, the Democratic Party of Wisconsin contributing $10 million to Justice Protasewicz's campaign in 2023, and I don't know how many millions the Republicans contributed to Kelly's. So Wisconsin's amongst the worst. Is a long answer to your very good question.
If I could just jump in, Jane, just for a moment, Joan. One of the things that you will see in this coordination issue is that often these groups will put on ads that are totally outrageous. And the candidate will say, it's not my ad. People will say, how dare you accuse them of being this or that, or shouldn't be a criminal defense lawyer, all these ads. And instead of the candidate, I mean, my view was the judicial candidate ought to censure them and say, I don't want this in my name. But often it is these independent groups that are putting on the very outrageous ads. And that certainly happened in the Justice Butler Gableman race, where it was a very racist race in my view.
I have a follow-up question for really all of you, and it relates to if it sounds as though 2015 really Wisconsin gutted its own campaign finance laws. And, we're trying to do this, George, you're working on the United to Amend project and trying to get various communities to pass resolutions. And I'm curious about what's more effective. Is it passing resolutions? And it's not clear to me what passing resolutions really helps to do. Having been in the fight for fair maps, we make it clear that the public supports this effort, but nothing happens because the legislature just doesn't care. Or should we be really working on changing Wisconsin's laws and going back to trying to strengthen some of Wisconsin's campaign finance laws, or do we need to do those both in tandem?
You said my name, so I'm going to respond. This is George. We need to do all of them in tandem. Well, our work is long-term movement building work, and the resolutions help us build power for the long term. So we are long-term, but fair maps, this judicial stuff you're talking about, is short-term, and all reform groups need to support each other for both the short term and the long term. So you're right, all of them have to be working together.
George, can you explain how the number of referendums that have passed, how you're going to get it on the floor? Have you been successful at all to get it on the legislative floor?
Yeah, good question. Excellent question, because people don't realize since 2013, we have had bills in the federal House and in both state houses introduced every session, right? So we have introduced bills. We can't find one senator in this country who will introduce it, including our own, right? But the House and both, so we have the bills introduced, and we're going to have them introduced again this year, right? So that's the piece. But this American Promise that we work with, they do the lobbying. They bring people in, they work with our people, and we help them. And they go in and they talk to legislators because they're in that reform component, the ones that work inside the system. And so we are working on the long-term piece now. If tomorrow our state legislator said, okay, we're going to call it, and we became state number 23, our next goal would be, all right, now let's start keep building this movement, because once we get to 34, you need 34 states to force it. Once we get to 34, we need to make sure they're going to write a bill that works, because you can be sure they're going to try to pass a constitutional amendment that does nothing. So our work will not stand, and our children and our grandchildren maybe will be doing that end work if we get there. But ours is long term. We don't want 178. We want to have 278 when we get legislative balance. All right. So until we have more balance in our state legislature, we're not going to win. We have to count on fair maps and everything else to get us to the legislative balance. Then we can win. I don't know if you got a little more detail you want.
Thank you.
Yeah. Thank you. Anne is asking if you can tell us more about what your constitutional amendment actually says. Someone else did post a link to it in the chat, so it's available there. But if you could briefly explain the constitutional amendment.
Yeah, real simple. As a matter of fact, in preface here, the language that we have both in our referendum, our resolutions, our state legislature, and our national legislature bills is all consistent. and it says at least two things, because each, a referendum has to be written out for people in resolutions, but the actual bill in the House is going to be very different. But they say these two things and maybe a little bit more if they want to. Corporation, only human beings have constitutional rights. Dash. No corporation, union, or any non-union entity. Point two. So that's point one. Point two. Money is not speech, and therefore it should be illegal for the government agencies to be able to limit money. So that's not the exact wording. Anybody can send me an email. I'll give you the exact. I'll send you the resolutions or the bills, or you can go on our line and our site and get it. So those are 2 points. A corporation is not a person, and money is not speech. Elevator. There you go. Elevator is. Corporation is not a person. Money is not speech. Thank you for asking that.
Yeah, thank you. Let's see, I know there's a few more here. In the ads for both current Supreme Court candidates, and this is from Louise, they claim to be tough on crime, et cetera. That's not really relevant to the work of the Supreme Court, is it?
The answer is no, it is not. The issue is whether there was a violation, either the statute or constitutional violation that resulted in a bad trial. And being tough is not an issue. The court doesn't sentence. The court actually does not even hear that many criminal cases. They usually end at the Court of Appeals because most of it's within the discretion of trial judges. So the answer is no. It's just what they think the public will want to hear is that they're tough on crime.
Janine, I'm going to ask you a question. Can you distinguish the difference between what a circuit court judge does and what a Court of Appeals judge does and what a Supreme Court justice does? Because the two candidates running are circuit court judges.
Right.
What's the transition that they will make? What are the 3 levels? How do they work? And how do the circuit court judges adapt when they're a justice?
Okay. Well, circuit court judges are your trial judges. In all counties we have, I don't know, it's probably around 200. I don't know what the number is of judges in Wisconsin. They're all elected in their counties. They hear all the what we call the trials. They do the jury trials. They do the court trials. The court, at a criminal case, what they do is they preside, and many of you have seen that either on TV or in movies or in reality, where judges are making judicial decisions. There's a court reporter, there are witnesses, and the court is often on some issues using discretion. That is, they can decide, do I give this defendant 10 years or do I give this defendant probation? They decide whether some evidence is too prejudicial. There's a lot of discretion at the trial court level. A transcript is made of whatever happens at that level, and either party has an absolute right in Wisconsin to appeal final decisions by a trial court. It then goes to our Court of Appeals. There are 4 districts around the state, and they work independently but partially together. Their decisions can become law, and they are reviewing what we call for error. Did the trial judge do something wrong? Is the discretion, was it erroneously exercised? Did they apply the statute wrong? Did they misinterpret a case? It's really analyzing. In that level, there are no witnesses. There's no jury. The defendants don't show up. It's all based on transcripts and briefs. Then whoever loses at that level can, what we call, petition the Supreme Court for review. The Supreme Court, like the U.S. Supreme Court, has discretion as to which cases it takes and doesn't take. And the cases, the criteria is really, is it the kind of case that's going to have statewide impact, that we need, a brand new statute when we had the sexual predator law suddenly enacted? What does that mean? How is that interpreted? So sometimes it's new laws. Unfortunately, it's been a lot of political issues in the last couple of years, but is it the kind of case that the court has to hear? Now, I'm not going to get into too much detail. There are methods, and they're being used more and more, to skip the circuit court and skip the Court of Appeals and file a direct action in the Supreme Court. That used to be very rare. It's not so rare anymore. And then the court has to decide whether to take it. If it's an appeal from the Court of Appeals, 3 justices have to say they'll take it, and the case is taken. So it's not a majority, it's 3. We don't know who the 3 are if they take it. We just know it's been given. if it is a bypass, that is jumping the Court of Appeals, or there's no Court of Appeals decision, then it has to be 4 judges saying it, taking the case. And unfortunately, one of the things that's happened in all this is our numbers of cases have dropped dramatically. You know, I don't know what the number was when I was on the court. I want to say somewhere between 70 and 80 cases a year. We would write these decisions. I think the court decided 14 cases last year. It is a very low number, and part of it's all this political maneuvering going on. You know, I was a circuit court judge, so I'm going to tell you that bringing that experience to the court, and both candidates have that, is really helpful, because you're reading the transcript of what happened in the trial court, and you can have a good feel of what happened and why they may have done it. That's not to say that there haven't been some really incredibly good justices who did not have that experience. They bring other experience. Sometimes they bring legislative experience, sometimes they bring academic experience, and they've been good judges as well. But you know, I think having trial court judges is a healthy thing on an appellate court, a Supreme Court.
Okay, thank you. Okay, Mara, you can continue.
Yes. Richard makes a comment that we really can't have optional set of limits on campaign financing, where some candidates get public funding if they agree to limits, but others are free to spend as much as they want. Either limits have to apply to all of them or none of them. Jay, that sounds like maybe it's for you.
Well, you know, that's a constitutional question. I mean, very famous decision, 1976, Buckley-Vallejo basically said, and Doug can chime in on this. You know, you can limit, you can provide public financing to candidates, but it has to be voluntary. You can't compel them. That's a First Amendment issue, and I don't know that that's ever been addressed beyond that. Other than if it's voluntary, you can provide sufficient public financing. And for many years, we were trying to get enough public financing to make it worthwhile for candidates not to be able to spend a lot of money. But the voluntary part of it has been pretty ensconced in the law.
I'll say one, that's all right. And the one creative attempt to get around the voluntary aspect of it was some states attempted to use what were called trigger funds, where if you did have a scenario where you had someone opt into public financing and then someone who didn't, and that person who didn't spend a significant amount of money, the person in public financing would then get additional funds so that they could keep up. And the Supreme Court struck even that down as an unconstitutional burden on the person who did not accept public financing. I'd love to know if anyone thinks that makes sense, but that's sort of where we are. And so I think you're absolutely right that the limits would need to be on everyone. But as Jay said, this is sort of where the constitutional law stands at the moment.
And that trigger law, by the way, was part of the impartial justice law that was enacted in 2009, but it was struck down the next year by a U.S. Supreme Court decision. You would know the name of was it McCutcheon? I can't remember the name of the case.
Richard, yeah, thank you. Richard also asks, is there any requirement that campaign contributions must come only from American citizens, or could, say, Vladimir Putin support a favored candidate with multi-rubles?
Who would like to take that one?
Well, if no one else will, I will tell you what I think I understand or what I've seen. This is tertiary knowledge. I have stuff I dig deep, stuff I have to pay attention to do my job, and stuff that I hear. I say, well, that's interesting. I wonder if it's true. But I understand there are some states who are trying to pass laws, and maybe have, again, this is how weak my answer is, to at least limit international money from coming in. But right now, as I understand it, there is no limit. They could give money to the PACs. But you need to do your research before you trust me.
Now, my understanding is that there are federal prohibitions on outside money from other countries that can be contributed in American or federal elections. I'm not sure if that would apply to state elections. I assume that it would, but but certainly a question worth exploring.
Doug, do you want to weigh in on that at all?
No,
Unfortunately,
Go ahead, Doug.
oh, sorry, I don't know if
No,
you're speaking.
go ahead.
Unfortunately, it's not an area of law I'm an expert in, but maybe
Okay.
Justice Geske.
Janine?
Yeah, no, I don't know of any limitation. Of course, we never had to ask that question until recently, right? I mean, you look at that last race we had, and we had governors and mayors from all over the country contributing $1 million checks. And so, you know, there's no reason why we couldn't expect that it comes in internationally and could be a problem. The problem is the reporting and who's overseeing these independent expenditures. But I really don't know what if there's federal law on it. I don't know of any state law on it.
Yeah, it kind of seems to me that state elections should be limited to in-state money, but I guess I don't know how you'd enforce that. Peggy asks, what's a typical process in states where judges are appointed rather than elected? Janine, maybe that's your.
Sure. First of all, it's different in different states. And I have to tell you, just so you know, Wisconsin, I've been appointed as well twice. When a judge or justice either retires or dies, it leaves midterm, the governor appoints somebody, and then you have to run in the next election, which is what I did both times. I'll tell you how it works in Wisconsin, and I can talk more globally. In Wisconsin, there is a governor's commission or committee, usually made up of prominent lawyers, sometimes judges from around the state, that screen candidates. And as long as that committee is a good committee, you may get good candidates. And they usually, you know, historically, you've looked for all those qualities that I described earlier in the candidates, that people are competent, that they have good writing skills, they're articulate, they are willing to run an election. And then often in Wisconsin, what happens is that committee advances 3 names to the governor. The governor interviews them and the governor appoints. That's what happens in Wisconsin. In other states, it is often some independent commission. And there's no question that that commission or group could be just as partisan and moneyed as you know, our elections. So it depends on what that committee looks like. But, you know, generally, and I know at one point I was doing some teaching in Vermont, and I don't know if it's still true, they actually had an appointment by the governor, and then there had to be confirmation by the legislature every, I think, 6 years, which I thought was a bad system because the legislature doesn't want to confirm somebody who's finding their laws unconstitutional. But I think that generally that's how it works. Then what happens in some states, we have what has been called the Missouri Plan or modified Missouri Plan. And it's what's happening in Pennsylvania. It happens in Illinois after the first election. Your name is on the ballot as a judge, and it's either an up or down vote. And depending on the state, there's 50% approval, there's 80% approval. And if you're approved, you stay on as a judge. If you don't get that percentage, then there's a new appointment for the position. There are a lot of states that have that. And I used to think that that was probably a nice compromise because people got to vote and had to know people. But what's happened is money has entered into those races as well. And that's happening in Pennsylvania. It's happened in other states where suddenly a flood of big money comes in to have people vote no. And some of those candidates, judicial candidates, have said to me, I'd rather have a real candidate running against me than this hypothetical person who's going to be better than I am. So there are all sorts of different models out there, but an appointment process should be, if you're going to have it, is as bipartisan and fair and merit-based as you possibly can have it.
Thank you.
I think we have time.
Gail asked if we do manage to get strong recusal requirements, is it a given that super PACs will no longer contribute?
Good question. You know, one thing I'll say is that in 2017, the petition that Justice Geske was part of came after Citizens United, came after the destruction of the campaign finance law in Wisconsin. And it was very, very strong. What it said was that if you are a Supreme Court justice candidate and you receive either a direct contribution of $10,000 or more, or an outside group spends $10,000 or more on your behalf, then if that organization, that group is a party in a case before you, you must recuse. Now, the only thing that's changed between 2017 and now is that there's millions and millions more dollars being pumped into our Supreme Court elections. So, I mean, my own view is, and I don't know if it's practical, my own view is that that was a pretty good recusal rule that they adopted back in 2017.
Yeah, I just
Thank
want to add that there's no guarantee that they wouldn't give the money, but if you have a judge who you really, really think is a good judge or may have a philosophical view consistent with yours, and you think that they may recuse themselves, if you as an organization, as a company, as a person, that you're going to knock that judge off, that will hopefully give pause. It's all we can do because of Citizens United. We can't tell the people not to give the money. All we can do is say to judges, you can't sit on those cases.
Yeah.
Thank you. I think we are at the end of our time. So I'm going to pull together a conclusion and we will end. So thank you to our great experts who have contributed so much information about our Wisconsin Supreme Court election. Hopefully now with this background, we're fully aware of the damage excessive campaign contributions and dark money from special interests have had on our court. We as voters need to know what Judge Susan Crawford and Judge Brad Schimmel will commit to for advocating for an effective and strong recusal rule. We need to press them on the record for their commitment. Only with a strong recusal rule will confidence in the rule of law and the decisions of the court be restored. And only in this way can we be confident that our new justice will work with the justices already on the court to recuse themselves, should any one of them have a conflict of interest or even the appearance of a conflict of interest. And it's the only way that we know that each judicial candidate will be ethical in his or her role as a Supreme Court justice. The League of Women Voters is presenting a second webinar on February 25th from 6 to 7:30 on how to judge judicial candidates in terms of their approaches to judging on the Supreme Court, which is quite different from being a circuit court judge, as they both are. We have excellent speakers that night. Please do check the League of Wisconsin newsletter and website to sign up for our second webinar on the crucial Wisconsin Supreme Court election, which will be deciding so many important cases for us. Thank you for attending the League's webinar. Good night.